discussion that is both broad and focused. And so, Professor Cisneros, I would have lots of other talks I'm going to hand to you for that kind of nifty trick. Really, really good. I am supposed to read something, so I will do that. This session is being recorded for broadcast. In order to have continuity and accuracy, we ask you to recognize that this is the section on constitutional law on resistance and recognition. And you've already heard about the CLE sheet, and please fill out the feedback form. And with no further ado, I'm going to turn to Josh. Let me just say, in case you haven't looked up in the dictionary, resistance means refusal to comply or an attempt to prevent compliance. Recognition means identification or acknowledgement. Let's see whether those terms end up meaning what we thought they meant.
So hello, everyone. So it's some good news and some bad news with resistance and recognition. So I'll give you one metric of the good news. Every year they ask people to say, what is your opinion on interracial marriage? So for example, in 1958, 4% of Americans favored interracial marriage. In 1968, 20%. In 1983, 43%. And recently it's almost 90%. Good, right? Progress. But there's another question that's a little bit more troubling. People are asked a question, would you want your son or daughter to marry someone of the opposite party? That is, if the parent is Republican, would you want your son marrying a Democrat? Okay. In 1960, 5% of people said they would be displeased if their child married someone of the opposite political party. In 2010, 41%. So think about this for a second. In 1960, only 5% of Americans favored interracial marriage, but 95% favored inter-party marriage. Today, it's almost the exact opposite. Cass Sunstein has called this partyism, this idea of a form of hostility and prejudice that operates across political lines. Sunstein writes that partyism is worse than racism, and in fact, people trust more people of their own race or the opposite party, as interestingly as enough. So with that, I actually thank you for inviting me to this panel to offer a little bit of intellectual diversity. I would also like to thank the AALS for recognizing the Federal Society's conference, long known as the Shadow Conference, but now we are out of the shadows. We have been recognized. So I think the professoriate is taking important steps to combat partyism. I cannot say the same for the United States government. So the topic of my talk is how gridlock in our Congress is affecting executive power or polarization. And I want to discuss three major cases. So the first is National Labor Relations Board versus Noel Canning. The second concerns a few different aspects of the Affordable Care Act's delays mandates. And the third is the immigration executive action. Now, I am not trying to persuade anyone that these actions are unlawful. If you'd like to read my forthcoming book, Unraveled, but that's for another day. Rather, I want to discuss how gridlock and polarization affects our separation of powers. So the Noel Canning case is an interesting one. For years, both Democrat senators and then Republican senators blocked all appointments to the National Labor Relations Board. And it got to a point with both the Bush administration and the Obama administration that it dipped below 3 members. If the board dips below 3 members, they lack quorum and they can't do business. So in the winter days of January 2011, the Congress, the Senate, had a 3-day break in action. And the president decided that that break was sufficient to make a recess appointment. They were having these pro forma sessions, but the president said, no, those don't count. Now, I'm not so much concerned about the meaning of the recess appointment clause. That's another topic altogether. But what I'm concerned about is an aspect of the oral arguments. And I go to a question posed by Justice Kagan to Donald Verrilli of the Solicitor General. And Justice Kagan says, it seems that, nowadays, the recess power is used not to deal with congressional absence, but to deal with congressional intransigence. In other words, the president has used the recess power not because Congress couldn't be convened, but to get around the Congress blocking their appointments. And the Solicitor General replies, well, you know what? If Obama didn't do this, the board was going to go dark. We'd lose the quorum. And Kagan replied, basically, so what? That's a result of the congressional refusal to fill the board. And then Justice Alito was saying, this is a very aggressive argument you're making. And then the SG said something that was very important. I want to say this very clearly. He said, quote, I think the recess power may now act as a safety valve given that intransigence. The recess power may now act as a safety valve given that intransigence. In other words, when we have this sort of gridlock in Congress, the president can turn to executive power to let a little bit of steam, right? To do stuff that maybe you could not do otherwise. The court jumped all over this. And by the way, David Posen has a great article called Constitutional Self-Help, where he describes these sort of maneuvers. But the Chief Justice, who knows a thing or two about filibusters and people voting against him, President Obama for one, said, look, you're latching onto this intransigence as a way to deal with something which you cannot otherwise do. Justice Breyer said, listen, this is a political problem, not a constitutional problem. And the justices, by a vote of 9-0, the other parts were fragmented, by a vote of 9-0, they rejected this notion that gridlock or political intransigence allows the executive to heighten his executive power. Justice Breyer of political opposition does not qualify as a circumstance to justify this. And Justice Scalia said, listen, you have no safety valve. If Congress says no, that means no. And the justices rejected that. So here we have an instance where Congress is being intransigent. By all means, they probably should have confirmed the people to the board. The same can be said to Democratic senators, but they didn't. They exercised the prerogative of denying with advice and consent. And the court said, no, you cannot use this executive power as a safety valve. Next, I want to turn to a thing called the Affordable Care Act. Some people call it Obamacare, including the president. And I am not trying to persuade you about any aspect of the ACA except for one small element. So there's something called the individual mandate. Effectively, this says starting on January 1st, 2014, people have to have a certain minimum level of coverage. Otherwise, they'd be hit with a penalty, or if you're John Roberts, a tax. And they were able to, incentivize people to go ahead and pay for this coverage. Now, the ACA's mandate has never actually gone into effect as designed for one very important reason. As designed, the ACA was meant to cancel old policies. It was meant to take these old, inefficient policies, cancel them, and let people go and buy on the new ACA exchanges. That was the design of the law. Surprise, surprise, in the fall of 2013, as the government shutdown was happening, as healthcare.gov spiraled out of control, people got these cancellation letters by the millions. And they were saying, wait a minute, my policy's been canceled. I thought you said if you like your plan, you can keep your plan. This was a major crisis that nearly derailed the ACA before it even started. Okay, so what happened? On November 2014, the president held a press conference, and he basically said, I get how upsetting this is, right? You know what? I'm the president. I'm going to do something about it. And they announced what became known as the administrative fix. Effectively, if your policy was canceled, you were not subject to the mandate penalty. This was nowhere in the law. He did it. Again, I'm not trying to persuade you of its legality. Let's look what happened. But what's distinct about this episode is at the same time the president was announcing its executive action, Congress was taking bipartisan steps to do just that. The Keep Your Health Plan of 2013 was a 2-paragraph bill. That's all it did, was that if your plan was valid in 2013, it will also be valid in 2014. The exact type of relief that President Obama did, Congress was considering it. And you know what? This bill passed the House 261 to 157, bipartisan. So you would think that the president would say, you know what, let's go pass this bill and give people relief. No, the president issued a veto threat. He said this would, quote, sabotage the ACA. Chutzpah, right? The exact same action which he did by executive fiat would sabotage the law. Congress can't sabotage laws. They make the laws, or at least I suppose it's supposed to. So this bill, which was 2 paragraphs long, would have codified this. The president opposed it. Now, it's not unreasonable why the president did this. Nicholas Bagley, who's been a huge ACA scholar, wrote, the president's willingness to press against legal boundaries is understandable. There's a toxic and politicized environment. If they make one change, they'll make another, fine. But it still is affecting the separation of powers when we allow these dynamics to occur. The final instance I want to talk about is immigration, and this has perhaps been the most significant one. 1 week from today, the Supreme Court will consider at conference United States versus Texas. In disclosure, I filed briefs in that case in support of Texas. But a little bit of a history. So the president has been unable to get immigration legislation through Congress. I support the laws. I think it was silly not to vote for them, the DREAM Act and the Comprehensive Bill, but they did not pass. Subsequent to these bills not passing, the president said, in the absence of any immigration action from Congress, we're improving this on our own. And he made quite a number of statements about, we can't wait. We can't wait for Congress. We can't wait for this. We'll have to do it alone. And this led to the policy that became known as DAPA, the Deferred Action for Parents of Americans. So within hours of the House announcing that they would not vote on his immigration bill, the president announced that he would do this. And I'll just read a few of the quotes. He says, I take executive action only when we have a serious problem and Congress chooses to do nothing. I will fix the immigration system on my own without Congress. He cited gridlock, inaction, indifference, saying, I'm going to go ahead and move out without them. Okay? Again, I am not talking about whether this was lawful. You can ask me after class, force of habit, office hours are by the cookies. So, right. But the point is, in light of this gridlock, the president again turned to executive action. So what are the consequences of this? I think there are 4 distinct observations we can draw about the American people, about Congress, the president, and ultimately the courts. So first, as our country becomes more polarized, and these inter-party marriage proposals prove this, right? The prospect of congressional legislation on a big scale becomes impracticable. To take an example, the ACA was a bill that perhaps in a different time would have appealed to conservatives. It was built on Heritage Foundation ideas. Governor Romney liked it. He was a rock-ribbed conservative, right? And these are things I explore in my first book. But this is an instance where even something which people may otherwise like, they won't because of this polarization. And this brings my second point. Okay, I have plenty of time. As the country becomes more polarized and fewer laws are passed, the executive branch becomes less constrained. And what do I mean by this? Perhaps in a different time, if there was a rogue president, right, who went out on a limb, people of his own party and people of the opposite party would both oppose him. But today, I don't think it's going to happen, whether it's Barack Obama, Hillary Clinton, or Ted Cruz, right? Half of Congress abhors the president, and the other half reveres him. So the legislative branch is really no longer equipped to use its institutional checks against the president. I think that's actually a very dangerous trend because of this polarization. In other words, you had Republicans who want to impeach Richard Nixon, right? You would not have Democrats who would want to impeach Bill Clinton, okay? Well, regardless of whether the indictment was valid, totally apart from this, right? And this brings me to my third point, right? With the country being more polarized and fewer laws being passed, and Congress no longer constraining the president, the scope of the president's executive power will continue to grow by leaps and bounds. Okay? Presidents can no longer achieve major legislative agendas through Congress, and they're no longer restrained by Congress. So now they have a broader platform to achieve unilateral accomplishments. The only limit, this is not a good limit, is the president's own conception of Article 2. Unfortunately, executive branch lawyers of both parties always seem ever ready to find increasingly dubious justifications for how to justify the action of the president in terms of statutory law and constitutional law. See Charlie Savage's new book, The Power Wars, and Jack Goldsmith's book, The Terror Presidency, for a discussion of this dynamic over the last 16 years. A necessary consequence of executive action is further breeding of distrust, which makes legislative change even more difficult. If the president ignored Statute A, why do we give him Statute B, which he'll ignore anyway? This is a downward spiral that does not bode well for our republic. Finally, the last actor in our separation of powers is, of course, the courts. I don't think we've quite seen how the justices will react to this increasing polarization. The arguments in Noel Canning and the unanimous reversal of the recent appointments are an indication that the justices do not see executive power as a safety valve for intransigence. However, in other cases, such as the DAPA immigration case, we'll present this issue squarely. Indeed, a lot of the big debates we have now over justiciability, standing to challenge executive action, and deference to administrative state after King v. Burwell may very well define the next phase of polarization and the separation of powers. Thank you so much. With time to spare, I cede my time to Erwin.
It's really an honor to be part of this distinguished panel. Over 40 years ago, I decided to go to law school because I believed that law was the most powerful tool for social change. That's great. I was inspired by the civil rights lawyers in the 1950s and 1960s. From the beginning of law school, I decided to focus on constitutional law. This panel ultimately is about the ability of constitutional law to achieve social change. My thesis this afternoon is that courts are necessary but rarely sufficient for resistance to social problems and recognition and implementation of solutions. That advancing freedom and equality almost always will require court action, but rarely will court action by itself be enough. I want to take 4 examples to illustrate this thesis. I want to take 2 examples where I believe there's been successful social change. One familiar to everyone in this room, marriage equality. One likely less familiar about the reform of the Los Angeles Police Department. And then I want to take two examples where social change was unsuccessful: school desegregation and providing a right to minimum entitlement to social services. Then I want to try to draw some conclusions from these examples about the use of constitutional law for social change, tying it back to our theme of resistance and recognition. With regard to marriage equality, it's so easy for us, since we've lived through it, to underestimate how dramatic and astounding the social change has been. In fact, as recently as the AALS meeting in January of 2003, and many of us in this room were present there, there was not marriage equality in a single state in the United States. Today, as we're here in January 2016, there's marriage equality in all 50 states, even Alabama, notwithstanding Chief Judge Roy Moore. I worry that relatively soon, our students, our future colleagues, will come to regard marriage equality as something that was just inevitable. I think they will tend to give the credit to the United States Supreme Court, as they will study about it in constitutional law by reading Obergefell versus Hodges. But what I would argue to you is that we should spend a good deal of time thinking about how was this effort for marriage equality successful? And the answer has to be that it was a combination of judicial action and political action, and it wouldn't have happened without both. Since all of this is familiar, I can sketch this quickly. Think about judicial action. The story has to at least begin in 1993 with a Hawaii Supreme Court decision in Berry versus Lewin, which said that the denial of same-sex marriage is a form of sex discrimination that would have to meet strict scrutiny. Though the Hawaii Constitution was amended before there could be a ruling on whether the law met strict scrutiny, it is Berry versus Lewin that led to the Defense of Marriage Act. There's no doubt that Berry versus Lewin is responsible for a good deal of the strategy and the litigation that followed across the country. Lawrence versus Texas in 2003 was another key step towards marriage equality. For there, the Supreme Court unequivocally said that a state cannot make a moral judgment that homosexual activity is wrong, but that's not a legitimate basis under the rational basis test of the Constitution. And of course, it was in 2003 that the Massachusetts Supreme Judicial Court, in the Gridlock case, became the first in the United States to find a constitutional right to marriage equality under a state constitution. The lawyers who devised the strategy here were brilliant. They decided to focus first on state courts and state constitutional law, so it would not go to federal court or the chance to go to the United States Supreme Court. They had a stunning success in Iowa, where by a 7-0 vote, the Iowa Supreme Court found a right to marriage equality. They succeeded in California. They weren't successful everywhere. In New York, by a 4-2 margin, the New York Court of Appeal rejected a right to marriage equality. It was over the eloquent dissent of Chief Judge Judith Kaye that's appropriate to recognize her today that she passed away yesterday, and her dissent was certainly a blueprint for courts to follow. All of this ultimately leads to federal court litigation, the Prop 8 litigation, the Supreme Court decisions in United States versus Windsor, Perry versus Hollingsworth, and ultimately Obergefell versus Hodges. But if we think of just the courts, we're ignoring so much of what led to this effective social change. And again, I invite all of us as constitutional scholars to reflect on what else contributed to the success here. Some of it undoubtedly was political efforts. The New York legislature legalizing marriage equality was a crucial step. The initiatives passed in states like Maryland, Minnesota, Washington, also were very important in this regard. Even the opposition to the initiatives that tried to amend state constitutions to prohibit marriage equality were important in terms of, were we supposed to go?
Keep going, you have 5 minutes left.
Oh, I thought we had 15 minutes, not 10 minutes.
I've been counting, you've been 10 minutes.
I've been 10 minutes, okay. Wow. Sorry about that. Then I'm gonna talk really fast in my other example. With regard to the other factors in terms of marriage equality, you also have the social culture change. You had what occurred as a result of TV shows like Will and Grace. You had what occurred in terms of movies like Kids Will Be All Right. There's the international effort. In the Netherlands in 2001 becoming one of the first nations to recognize marriage equality. All of this, I think, is a key part of the story. Let me tell a second success, and that concerns the Los Angeles Police Department. Anyone who observes the Los Angeles Police Department would say it's vastly different today than it was 15 years ago. Now here, the change is not successful because of the United States Supreme Court. We know as constitutional scholars that the Supreme Court decisions with regard to policing have been terribly regressive. Rizzo versus Good in 1976 that refused to allow a court to reform the Philadelphia Police Department on account of federalism concerns. Or City of Los Angeles versus Lyons in 1982 that said that there's no standing to challenge a police practice, even one that kills people like chokeholds, because a person can't show who choked in the future. Los Angeles has a long history of abusive policing. And you can go back to the 1950s, you can look at the events that led to the Watts riots in the 1960s, you can look at the Rodney King beating in 1991, the Rampart scandal of 2000. And there's a clear pattern in Los Angeles. There would be a scandal, there would be reports and recommendations, some would be implemented, some not. Then the city would declare victory over the problem until the next scandal. There was deeply embedded racism in the Los Angeles Police Department. When the chokeholds led to the death of many people, and in fact, it turned out almost all were African-American men, the then chief of the Los Angeles Police Department was asked, how come it's almost all black men who have died as a result of this chokehold? And Daryl Gates, the police chief, said, quote, it's because of physiological differences between black people and normal people. That's a direct quote. Well, the Los Angeles Police Department changed dramatically, again, because of a couple of things. One was court action. The United States Department of Justice said it was going to file a lawsuit against the city, claiming a pattern and practice of constitutional violations. That led to a consent decree, almost 200 pages long, that implemented many reforms that were long overdue. To give one simple example, it led to tracking the disciplinary record for police officers, something that had never happened. But it wouldn't happen just by itself. Community organizing and pressure was crucial. A mayor being politically courageous was essential. James Hahn, the mayor who had been elected because of support of the black community, fired a black police chief, Bernard Parks, put in a new police chief, Bill Bratton, who was committed to change. I was going to go through two other examples where there had not been reform. One with regard to school desegregation, and one with regard to the failure to establish minimum entitlements. And say that in both instances there was failure because the courts did not step in effectively to bring in school desegregation, because the courts ultimately abandoned the idea of poverty as a suspect classification and the notion of minimum entitlements. I would conclude by drawing three conclusions from the examples that I've mentioned. One to keep in mind is that...
Go ahead.
Okay.
Yeah. Josh is giving you his minutes.
I'm giving you my time.
Josh is
Okay,
giving
that's okay. I'll be very brief. I apologize. Wanted to draw three points. One is that minority groups of all sorts will rarely be successful through the political process. The Caroline Products footnote 4 was right. It's the nature of being a minority that the political process will rarely be hospitable. If you think of all of the things that lead to success in the political process, who gives money? Who has the votes to form coalitions? Who has success in electing people to legislatures? It's the very nature of being a minority group that that's not going to happen. And that's why court action is so essential in order to lead to successful social reform. A second point that I would make with regard to this is we can learn from the past and see the blueprint for what success would need. I think one of the most important issues that constitutional law needs to take up is how to deal with the growing wealth inequality in our society. I think we desperately need to revisit the issue of minimum entitlements. But in order to do that, we need to form a strategy that both uses the courts and uses the political process. And in that way, the success of the movement towards marriage equality provides a blueprint for this and other areas of success. The final point that I was going to make is that the criticism of courts that's often found in the academic literature is seriously misguided. Many, such as Gerald Rosenberg in his book, The Hollow Hope, say that the courts inevitably fail. But what they show is that the courts are often insufficient by themselves. But to say that they're insufficient doesn't mean that they're unnecessary. And that's an enormous difference as we think towards the future. So I began by saying I went to law school believing that law is the most powerful tool for social change. I still believe that the social change sure is a lot harder than I thought it was going to be when I applied to law school.
Good afternoon. First, I just want to thank Laura Cisneros again for her invitation. Thanks to the section for putting on this panel. I'm delighted to be here. So Josh and I are clearly having the same dreams. We sort of shared our topics earlier this week. I was sort of delighted and not so delighted to find out we would sort of be talking about the same things. But I also think that there's a backstory that I think touches on Erwin's discussion, and I think we'll touch on Rachel and Robert's discussion in just a few minutes. That I do want to highlight. That is to say, our polarized political process does not come from nowhere. Right, that our polarized political process is a post 1960s phenomenon. It is a post incorporation of African Americans into the Democratic Party in the South, and the realignment of particularly white Southerners out of the Democratic Party into the Republican Party, but not simply that. That is to say, that Republican representatives, even outside of the South, have become more conservative. But the dominant proportion or the dominant explanation for partisan polarization is in no small part due to the browning of the Democratic Party and the increasing dominance of Southerners in the Republican Party. So I take that, and I'll come back to it at the end of a talk that I think will at least in some sense cover some of Josh's tracks and try to think about them in a slightly different way. That is to say, in the ordinary literature on public policy change and transformation, we think of policy change as being explained in and through a process of sort of punctuated equilibrium, right? That we have a steady state of affairs. We might have a crash of 2008. We might have a recession. We might have car accidents that take the lives of kids and parents. And somewhere in that punctuation, we do something, right? We either choose to regulate automobiles, we either choose to deregulate airlines, and that's primarily the way in which we've thought about the process. And I think Josh is absolutely right to say that's not, in some sense, how we think about the process under polarized partisan congresses. That polarization sends the message both to presidents and to parties that simply winning elections with even moderate-sized majorities may not be enough. That 55 votes in the Senate may not be enough, wouldn't have been enough to get you the Affordable Care Act, right? And so transformation in the policy process is nothing short of occupying and occupying in a big way all three branches of the national government. And so what are you to do when that's not your luck? Barbara Boxer, who was the former chair of the Senate Environmental and Public Works Committee, is reported to have said, and I'm going to quote, she says, "A lot of you press me on where the bill on climate change is. Where is the bill?" She responds, "There doesn't have to be a bill." Jonathan Chait says, "Boxer is right. We don't need a law because Richard Nixon and his Congress, filled with what we today call environmental wackos, already passed it 40 years ago." That's the Clean Air Act. Describing what he says as the options available to the president in a post-cap and trade legislation world, he says, "All the myths of the presidency we cling to are perfectly useless here. The heavy lifting will be, by conventional terms, invisible. The fight of Obama's second presidential term requires only the simple exercise of power." I don't want to sort of judge the exercise of that power. The exercise of that power, with which I mostly agree. That doesn't mean it doesn't raise important and interesting constitutional issues, some of which I think Josh has explored quite well. There are a few that I want to lift up, and then I want to kind of back out of that and think about what it means for us to think about constitutional law and constitutional change in an era and all of Josh's minutes are gone, right?
I gave all to Erwin. He took them all.
In an era of policy change that can only take place when you have in fact occupied again in a big way all three branches. So I won't sort of survey too much of the land. Again, to go back to the Affordable Care Act, there is a lawsuit I guess it's headed to the U.S. Court of Appeals for the D.C. Circuit, in which the district court has upheld the standing of the U.S. House of Representatives on the appropriations authority that the House of Representatives alleges has been undermined by the Secretaries of Health and the Treasury in implementing the Affordable Care Act, right? And this, again, follows on the heels of NFIB and Sebelius and King versus Burwell. In the immigration context, we have the president, again, moving forward on DAPA and DACA. But the president has moved forward on those in light of the failure of comprehensive immigration reform, right? And those failures are not just failures that have taken place in the Obama administration, but failures that took place as well in the Bush administration. The Bush administration, George Bush, in contradistinction to his party, favored a much more liberal, comprehensive immigration reform policy, but in some sense was held hostage by conservatives within the Republican Party. And the reform package that was produced in response to Bush's sort of liberalized immigration reform policy failed. In 2010, the DREAM Act legislation failed. That was a kind of paradigmatic bipartisan piece of legislation submitted by Dick Durbin and Orrin Hatch that would have given a pathway to citizenship for immigrants. It passed the House by 216 to 198, but failed to get 60 votes in the Senate. And then in 2013, we get the Gang of Eight, right, who come up with again, a bipartisan immigration reform package that gives us a pathway to citizenship, got 2/3 of the vote in the Senate, but no vote was ever held in the House, right? Speaker Boehner never brought the vote to the House. If we think about the things that might stymie policy change in Congress, it's not just intense party polarization, but also intense party competition. And I want you to consider the fact that from 1954 to 1994, the House of Representatives changed majorities 0 times. From 1954 to 1994, the Senate changed majorities twice. Once from the Democrats to the Republicans after the 1980 elections, and again from the Republicans to the Democrats after the 1986 elections. In the post-1992 world, the House of Representatives majority has changed 3 times, and the Senate has changed 5 times. Given the greater or the increased occurrence of these flips, you actually might have parties in the out party that say, we don't need to compromise on this, right? That is, the Democrats who don't need to compromise, and this is in some sense anticipating Rachel's presentation, to the extent that Democrats want, and in some sense really need, Latinos to become wedded to the Democratic Party. And to the extent that the Democrats do not risk losing Latinos because of a failure on immigration reform, not passing immigration reform doesn't become that big a deal. And to the extent that we have a Democratic president who wants Latinos not only to be wedded to the Democratic Party, but to be wedded to the presidency. That is to say, the importance of the presidency. The president's actions in this executive domain demonstrate that. It demonstrates the fact that, look, it's not just the Democratic Party who's looking out for your interests, but it's the president, right? And so the presidency becomes a very important player, and that becomes fundamentally important. Again, in the climate change, Barbara Boxer's quote that I started with is a response to the failure of cap and trade in 2010. Again, everyone thought cap and trade made sense, right? It was a law and econ program, right? And so the sense was in 2009, you'd get together with a handful of Republicans and the Democrats who weren't from West Virginia and Ohio and the right coal-producing states, and you'd make something happen. And that didn't happen, right? And so now you have a president who again is saying, well, I've got to do something. And I'm going to do it over here in this administrative forum. And I'm going to do it at a stage in my presidency when we are beginning to think, well, what's the good of the presidency anyway? Right? That is to say, again, just this week, President Obama has reinserted himself into the policy debate on gun control. And he can do this, why? Because Mary Landrieu is no longer in the Senate. That is to say that there is no reason now to cover the asses, to be blunt, of Southern Democrats on gun control, right? And so this, again, the demographics, the new demographics of the Democratic Party, Latinos care about this. And so the people we've already lost. And so in some sense, this goes back to Erwin's point, right? These sort of non-court-centered dynamics that push policy transformation forward. But they also invite the court in. They've invited the court in to articulate novel conceptions of standing, right? But those of us who might shudder at the idea that the court recognizes the standing of the House of Representatives should remember the fact that we were the same people who might have been applauding in Massachusetts versus EPA when the court articulated what we then thought was a sort of novel conception of state sovereignty, right? And state sovereign interest in another context of policy breakdown on climate change, right? To push the Bush administration, or at least to act where the Bush administration refused to act in a policy domain. So my last statement. How then do we think about constitutional transformation? If we think that constitutional transformation, and some people smarter than I think that constitutional transformation can happen in the absence of amendments, right? You've heard of this. They at least had statutes. How do we define the constitutional parameters of this era in which we reside, in an age in which we don't have amendments or statutes? how do we think about what is in fact happening? And something big is in fact happening. And so this is not your grandfather's New Deal, right? But there is something happening, and the question is it of a sort of constitutional nature? Will we be able to look at this and say there is a coherent, cohesive conception of what the state looks like and is the state's responsibilities, and give name to it? And I don't know what that might look like in an absence of statutory enactments. Thank you.
Good job. Good job.
Well, Bob and I also want to thank Laura for inviting us to be a part of this panel and to have the opportunity to share the exciting work that we're doing at the American Bar Foundation through a new research initiative on the future of Latinos in the United States, law, opportunity, and mobility. And of course, this is a constitutional law session. So you might say, what does your project actually have to do with constitutional law? Because this is about the Constitution of the people. The Constitution draws us together, but we the people are changing dramatically. It's not just the breakdown of ordinary politics. It's not just unprecedented levels of inequality, levels we haven't seen since the Gilded Age. It is also a demographic transformation. And here you see data on Latino population growth from 1970 to 2010, and then projected growth through 2050. And you can see here that the Latino population grew by over 5-fold from 1970 to 2010, and is projected to grow by over 2.5 times by 2050, so that by 2050, about 30% of the American population will identify as Latino. This is unprecedented, because even at the height of the civil rights movement, only about 1 in 10 Americans identified as non-white, and they were overwhelmingly African American. Now, in some states, including my own home state of California, the future is now. In 2010, 5 years ago, Latinos were already 38% of the population of California. They just recently passed the mark of the largest plurality group in the state. And by 2050, they'll be nearly half of the population. So the future of Latinos is not relevant only to Latinos. It is relevant to the future of our nation. So one of the things that we discovered is that there's actually not all that much out there. And that was the genesis of this project. Justice Mariano Florentino Cuellar had said, we really must address these issues. There's such a paucity of information. And you might ask yourself, why is that? And I want to share with you an anecdote that Dean Baquet, the first African-American general editor of the New York Times, offered in an interview with Charlie Rose. He was asked about his mentors, and he was describing a mentor, and he had asked his mentor, what was the big story that we as journalists missed? And his mentor said, it was the great migration of African Americans out of the South. And Dean Baquet said, well, why do you think we missed it? He said, because no one in the newsroom had moved from the South. No one had family or friends who moved from the South. So we didn't even know it was happening. So our goal is to fill the knowledge gap in several ways. One is to offer sustained interdisciplinary research. That has been the signature feature of the American Bar Foundation's work. But we feel that this is special and urgent, and we want to do that research with change agents at the table from day one. Because we need to build networks that will create a system of knowledge generation. We also want to promote teaching, innovative approaches to teaching and leadership training. The Latino population is disproportionately youthful, and so they will become the leaders in the future, and we think it's very important to get them ready to deal with what will be very complex issues. And finally, we want to raise public awareness of these issues. We found that immigration dominates stories about Latinos. There's almost a dichotomy. Immigration is Latino, civil rights is African American. This can't be right, and we need to correct that. So what we began to do over the summer was to lay a foundation that would become the basis for the work we'll be doing in the years to come. And I now want to turn it over to Bob to tell you a little bit about that foundational work and some of our future projects. Don't use our 15 minutes.
Right, so I first of all want to acknowledge the leadership of Rachel Moran in this effort. Rachel is the inaugural Newcomb Chair of the American Bar Foundation studying diversity in law. And she really has driven this project. In just 6 months, we've accomplished a huge amount of work, in part through Rachel's strong leadership, but also the resources we have at the American Bar Foundation. We have a great research team of graduate and undergraduate research assistants. Part of the work we did over the summer was to compile a extensive bibliography of all the scholarly work on Latinos in the United States, as well as media sources. And that annotated bibliography is going to be available on the project's website. We also have done a mapping, literally a mapping of Latino serving organizations in the United States, in which we cataloged where the location, using geocoding software, actually coded where these organizations are in the country. In this map, the dots are the Latino serving organizations that we've identified. The shaded areas are areas of intensity of the Hispanic or Latino population. And so it's, to a large extent, intuitive. The largest concentration is in California, both for the dots as well as for the dark colored areas, followed by Texas, Florida, the Northeast, with Washington and New York, and then Chicago, the Midwest. Those are the 4 main areas of Latino concentration in the country. And yet, if you look at the map, and there are large swaths of the nation in which there's a lot of dark blue, but no dots, which indicates that there's a mismatch between the kind of Latino serving organizational infrastructure and the presence of the Latino population. We can take this mapping technology and drill down to different regions and locales. This is the map of California. So we can see the dots located on the map in California. You can then take it down to the level of the city and the actual organization. So the particular dot that we're focusing here is the Southwest Voter Registration Project. And so this mapping technology we're going to pursue as we proceed through this project. But it's also very powerful. At this point, it's largely descriptive, talking about where these organizations are, but then we can actually move into a more advanced analytic approach to do formal network analysis about the extent to which these organizations get involved in the same issues or different issues. Another key pillar of this project is a set of regional roundtables, and then hopefully a national summit. And the foundational work that indicated where Latino serving organizations are and where the Latino population is have informed us about where we should try and have these regional roundtables. And so we're planning ambitiously 5 roundtables around the country, starting in Chicago, then in Miami, then in the Northeast at Yale Law School, then in California at Stanford, and then finally in Texas, and then hopefully a national roundtable, which we'll have hopefully in Washington, D.C. or in Chicago. And the method for these roundtables is also innovative, we think. It is to bring together scholars, both legal scholars and non-legal scholars, as well as who we're referring to as change agents, who are political leaders, lawyers, activists, philanthropists, the news media, students, and have them come together and have a set of roundtables in which we talk about alternative scenarios for the Latino population, and thinking about where we will be in the year 2050. And we're referring to the 2 different trajectories that we might observe for the Latino population. We've heard that demography is not destiny, and it matters what we do in terms of policy interventions and choices. So one set of indication or one set of pathways would be the vicious cycle, making mistakes that would doom us to a certain kind of negative trajectory. But the other would be what we would refer to as the virtuous cycle, in which if we take advantage of opportunities that are presented, so we can move forward in a much more positive trajectory. And for these roundtables, we primarily are focusing on 4 areas: immigration, education, economic opportunity, and civic and political participation. So,
Okay, so as I mentioned, we're also doing innovative work on teaching, and this is a way to revisit We the People, because inspiration can come from unexpected places. And while we were working, the court said that they had found probable jurisdiction to hear Evanwell versus Abbott, which proposes to change the one person, one vote principle to one that looks at your voting age eligible population. And this would have severe negative consequences for Latinos because of the proportion of non-citizens, people under the age, voting age, and people who have had, for example, felony convictions. And just to give you an idea of the impact, you can see here the difference between the total population, the citizen population, and the citizen voting age population. I have to say, the citizen voting age population doesn't have the same ring to it, but you can definitely see here that the attrition for Latinos is the largest of any group, not just because of the number of non-citizens, but because of its disproportionately youthful population. And so we wanted to see who was getting involved in this case, which is of such moment for the Latino population. And so here we have a heat-seeking map, which tells you the density. We love maps in this project, we really do. But you'll see the Northeast was the place where most of the amicus briefs came from. And again, in these areas Bob had mentioned, the Texas area, the California area, you also saw some. Now, if you drill down a little deeper to the actual amici, and we've tried to color code it, I know it's a little hard to see, but you'll see here that a lot of the briefs for the appellees who are opposing the change to the rule came from areas with long-standing Latino populations, although they weren't necessarily all by Latino constituencies, the Northeast, Texas, and California. But when you look at the briefs filed on behalf of the appellant seeking to change the rule, you'll see that some of them are in areas where the Latino population has recently arrived. The city of Yakima, Washington filed a brief. Why? Because they had to change their voting process because of demographic change in the population, largely due to the arrival of Latinos. They don't like it. And the other thing you'll see here is that there are areas with strong Latino growth, if you'll think back to the map you saw earlier, like the South, where there's no engagement, very, very little. And even in the Midwest, where there's been a lot of population growth, very little. Now, what we wanted to do was to see what the role of law schools was in this case. Because we know that Howard Law School played a seminal role in the civil rights movement. Today, there is no equivalent of Howard for Latinos. Frankly, I'm not sure there's an equivalent of Howard for African Americans. But if you look here at the landscape of law school involvement, one brief was filed on behalf of the appellant seeking to change the rule. That came from Chapman. And the other two supported the current standard, one person, one vote, one of which came from the Brennan Center. Is there a way to do this? This is Bob's laptop, not mine. And so, just hit yes. No? I don't care. It's not my laptop. So the other two came from the Brennan Center for Justice, and one was filed by Nate Pursley at Stanford and some other faculty. Only the Brennan Center for Justice addressed the issues affecting the Latino and other communities of color. The Supreme Court clinics were not actively involved, and there was no evidence of cooperation between the centers that did file and Latino organizations. And so we have a wonderful advisory council, and we went to them with this and said, we need to do something about this. And they said, but wait a minute, Supreme Court cases are exceptional. What about lower court cases? So we did a little additional research. Here are some key cases in recent years affecting the Latino community around immigration, the labor market, wage theft, politics, education, and you can see for yourself how many law school clinics were involved in filing amicus briefs. The next question is that because there weren't any clinics available? And the answer, I think, has to be no. More maps. The direct service clinics are not as relevant, but as you can see, there are a number of appellate clinics, including in the West, particularly in California, that could have been involved in those cases. And similarly, there are Supreme Court clinics around the country, mostly in the Northeast, which is very interesting, and legislative clinics, again, concentrated in the Northeast. But there were some clinics in California that could have been involved. So why didn't it happen? I think the Latino population has grown so rapidly that these connections between that constituency and the clinics hasn't happened. And in addition, many of the clinics don't coordinate with each other across different law schools. So we thought, here we have a wonderful asset, all these marvelous clinics that have grown up, and we have a technology that could collect all of those clinics and do for Latinos a kind of virtual parliament. And so our proposal is to create a network for justice, one that will connect law school clinics, civil rights lawyers, law firms supporting clinics, activists, and public interest organizations with the goal of advancing justice for Latinos. We think that we will facilitate partnerships among these stakeholders. We think we'll have more deliberate and strategic approach to the issues. We think it will help to fill the tremendous access to justice gap in the Latino community because advocacy organizations have not been able to keep up with the growth. And we think we'll train the next generation of lawyers and leaders who will be aware of these communities, their needs, and future challenges, whether they go to a law firm, a public interest organization, or government. We have a website where we have a beta site, which we're going to launch as our official website. That would include a brief bank along the lines of what Harvard did, as well as model legislation. We think statutes matter too. We would have current research experts. We would help to inform the media, events, leadership training opportunities. So we're very, very excited because our goal, returning to the theme, is not just to be recognized. It is not just to resist, but it is to transcend those phenomena, to take our rightful place at the table in defining who we the people are and will be, because at the heart of democracy is the root of demos. Thank you.
Timing.
Let's applaud longer, come on.
I think that's the Senator Schumer, maybe. I don't know.
Okay. Well, we have some time for discussion. I will start it off, and I want to apologize to everyone that I had to cut off, and please feel free to bring in all the comments that you wanted to make. I think this was a tremendous panel and tremendous discussions. To go back to my question, what do we mean by recognition and what do we mean by resistance? I think we really saw both very different meanings, but also some wonderful interconnections. So Josh, I think, helped us look hard at what has been the historic treatment of resistance within separation of powers as historically understood, and how has it changed. I think it's really interesting that Josh made reference to Jack Goldsmith. Actually, I would also point to his second book, or his third book, I guess, which
You're
is
a very good dean.
Power. That is my job. That is my job. But his book, Power and Constraint, in which he talks about, yeah, you're right, the traditional understanding of separation of powers is pretty much shot, but there are new mechanisms to have checks and balances, and he emphasizes journalists and also activist lawyers. And those are two comments that I want to thread through the rest of my comments, that the resistance and maybe recognition of constitutional law these days, I think, involves other actors besides the traditional triumvirate of the federal government or even the state, the federalism system. And I do think that journalists, or shall we say bloggers, and digital media is certainly one that I would put. I think there have been implicit amendments of the Constitution and certainly the Voting Rights Act and other kinds of fundamental civic elements because of communications, but also the role of activists, whether they're NGOs or there are lawyers. So I thank you, Josh, for that comment. And I think triggering, I think, will be a very good way to broaden the understanding of where is resistance and where is recognition. One small question to you is in your ACA example, when President Obama, again, I agree with you, let's not get into whether we agree with him or disagree with him, but when he threatened a veto, is that a departure from traditional separation of powers, or is that an expression of traditional separation of powers? The president, after all, has the veto power. So how do you see that? So I'm going to do everybody, but everyone will have a chance to respond. Erwin, your wonderful statement about both your autobiography, which is very similar to mine, and your reasons for going to law school, and your powerful statement that courts are necessary but not sufficient, or maybe they have a role, but they're not sufficient in social change, I think is terrific. And I would just now extend, and as you did, the other actors to include not simply the legislature and not simply the executive, but also media and NGOs and social movements. And all of the examples that you described, as you implied, include many of those participants. I do wonder, in the particular example you gave of the LAPD, the lawsuit that ended up in a consent decree was brought by the Department of Justice. That seems to me not a court story. That's a story about executive choice, about what lawsuits to begin to bring, and whether it's executive action or other lawyers. I think that that's just another very important player here. And as Jack Goldsmith talks about Guantanamo lawyers, the lawyers who are initiating accountability efforts, even if the courts reject them, that then trigger changes in public consciousness and initiative. And I just want to introduce the question, if that's a form of resistance, what's the backlash against them? And what do we need to anticipate in that respect? And as we turn to Charlton, whose introduction of political science information, it's kind of mind-boggling. Separation of parties rather than powers, I think, is one aspect of your story, but also the regional story. There's something about your analysis that seems, as you indicated, a preview of what Rachel and Bob are doing, because demography is a very important element as well. I did wonder, as a question for you, whether the party story is sufficient, because as you pointed out, President Bush also wanted immigration reform. So there's something else going on besides division of parties. And any further thoughts you have about that, I think would be really helpful. And I think we're seeing that in the current election too, the divisions within parties. And do we have sufficient mechanisms under our Constitution for the reformulation of political parties, or for the expression of differences of views that can't be contained within the party structure? And in the continuing theme about other actors besides those specified in the Constitution, I think that your analysis also suggests the significance of players besides those named in the Constitution. And in your example of DAPA and DACA, it does seem to me an interesting question whether, in the same spirit of what I asked to Josh, it's a departure from the traditional separation of powers, or is it actually an underscoring of it for the president to announce a policy that exercises power that the president has to choose how to allocate enforcement resources, but to do so publicly? Is that a departure from the role that the president has, or is that a way to actually produce more transparency and enable more response by both the formal other parties, the other actors in the constitutional scheme, and then still other actors? So that's my specific question to you. And then for Rachel and Bob, I think your story is the recognition story, even more than the resistance story. You're telling us we need to recognize transformations in who the we is, which is a more fundamental way to understand what constitutional law is than the way we usually talk about it. And Bob's story about the failure of the media to understand the Great Migration is, I think, a sobering reminder for all of us about that. I was very struck by your use, as is echoed by others on the panel, of other disciplines. I mean, this is a really multidisciplinary panel, and your turn to mapping and network analysis really do underscore this. But I have a question for you on the resistance front. You identified the tail end, that in some of the lawsuits that people are bringing, maybe it's a resistance as opposed to recognition. And to some extent, anticipating how your research project is in one direction, how are you going to anticipate the resistance? And what will be the counter moves by others? And I guess I would put that to everyone in the panel, but most specifically to Erwin. The social changes that you were drawn to when you went to law school, very much the same as me, would be one way to tell the story. But there's another story, which is the way in which Brown versus Board of Education provided a template for other social movements going in very different directions. So whether it's the Right to Life movement, or it's the school voucher movement, or it's the efforts to change the Section 5 enforcement power of the Congress under the 14th Amendment, there are deliberate efforts to use the courts and other mechanisms for social change, pushing in a very different political direction than you were favoring. And so I would put that to you and to the whole panel when we talk about recognition and resistance, which direction? And once we have multiple points of view, not just 2, but 3, 4, 5 different vectors of politics, how do we think about the role of the Constitution in enabling civilized discourse and maybe resisting the hijacking of our Constitution? So thank you all, and I open it up to you all to respond.
All right, I'll start, and I'll give the rest of my time to Erwin. Or maybe I'll spread it apart to recognize everyone. So I think we do have a new reality, and Charlton's point was extremely well said. Usually when the president comes to power with 51 or 52 senators, he can pretty much get what he wants done. But in the landscape of today, that's not possible. That's not possible. After the president lost a 60-vote block in the Senate with the Scott Brown election, everything fell apart. He hasn't really passed any major laws since then. So the president's frustrated, and I get that. I can see the frustration. So what the reaction is saying, okay, if the Congress won't give me what I want, I will try and do as much as I can within my executive powers. I won't agree with everyone whether he has those powers. I'll put that aside for now. But the point is, this still frustrates the constitutional design. Our Constitution was designed for gridlock. Go back to Federalist number 10 discussion of factions. Our system was designed when people don't agree, things kind of grind. Well, we don't have a parliamentarian election. Senate Levinson hasn't prevailed yet, right? We're not able to hold a referendum when the president is, and when people aren't happy. So until we have some sort of constitutional change, if the Congress disagrees with the president, well, things don't get done. Now, that's not good. We want things to get done. We want laws. But you can't have laws simply because you want them. And I think until a president recognizes that, we'll see this continued expansion of executive power by leaps and by bounds. Erwin?
Sure. Okay. Like 3 quick points. First, Mark, to answer your question about the Los Angeles Police Department, the courts were truly essential to reform there. If the LAPD was not subject to lawsuit, it would not have been reformed. And when the consent decree was finally entered into, it was only because it was aggressive judicial enforcement by a district court judge, Gary Pease, that it had any meaning. So courts were crucial. Second, you're absolutely right that Brown was a template for many social movements. One of the things that I tried to suggest is that I think the success with regard to marriage equality should be a template for social movements into the future. Also, of course, conservatives as well as liberals can use the courts. Look at the effort to try to eliminate affirmative action through the courts. Or look at what happened with regard to Section 5 of the Voting Rights Act through the courts. And so it's a tool that can be used either way. The third quick point I wanted to make is in response to both Josh and Carlton, who are talking about polarization. The court is not more polarized now than it's been at many times in American history. It's just that it's more polarized along political party lines. And I think it's important to keep that in mind. Think about the deep divide in this country over abolition at the beginning of the 19th century. Or think of the deep divide in this country at the Civil War. Or in the 20th century, the deep divide in this country over civil rights in the 1950s and the 1960s. Or over the Vietnam War in the 1960s. I don't think there's more polarization now than there was at those points in history, probably even less. What's different now is that ideology corresponds to the political party more than it has before. No longer are there the Southern Democrats who are very conservative, part of the Democratic Party. No longer are there liberal, even moderate Republicans. So when we think about polarization, it should be, I think, clear that we're talking about is polarization along political party lines and what that means.
So let me say yes. That's absolutely right. But that has implications. It has implications for your statement with respect to economic inequality, right? And that is to say, when we had a Democratic Party that was filled with both Southern segregationists and people who believed in an activist regulatory state and a welfare state, it was in fact easier, it seems to me, to think about an activist regulatory welfare state when there were some Republicans who thought that was a good thing, and lots of Democrats who thought that was a good thing, despite all of the other. I do think the sort of ideological purity makes, particularly the point around economic inequality, harder to do. To go back to the question about Bush and whether Bush is a departure. Bush is both president and party leader, right? That is to say and we can think about Bush's differences from other Republicans as an attempt to try to sort of act with the authority of the president, but to also act with the authority of the party leader, right? That is to say, I want to build a Republican Party. He comes from Texas. And so he says, look, don't be stupid on this. I want to be able to win Texas for generations. How do you do that? And can we afford to articulate immigration policy that wouldn't allow me to get elected? And so I think that the sort of two hats on the person who is in the presidency might complicate what we think of as the separation of powers issue. The departure question is an interesting question because I think that in an era of intense partisan polarization, what some people try to pass off as incrementalism becomes articulated as departure, right? That is to say, the Affordable Care Act for some people was, look, we've expanded Medicaid for 30 years. And here we are offering yet another expansion of Medicaid, right? Henry Waxman expanded Medicaid every other year throughout the Reagan and Bush years, right? And so there was a sense that this was incremental, but understood in 2010, it becomes transformational. And so I don't know what to make of, because I think departures and incrementalism can be framed in ways that participate in the very polarization that we're sort of talking about.
Well, I think these are very important questions, and as I mentioned, I think we're in a very different historical moment in the period when the civil rights movement was launched and had some really wonderful breakthroughs in law and policy, because we were in a post-World War II era, which flattened out a lot of the wealth and income inequality because global wars do that, according to Thomas Piketty. And the other thing was we had a government that was investing substantially in returning veterans and the creation of a middle class, but that effort was racialized. And so there was not equal participation in that middle class creation. And so today we see levels of inequality that have risen. We've actually seen declining intergenerational mobility in the United States, and we see astonishing wealth divides based on race. And indeed, during the Great Recession, households headed by a college-educated Black or Latino fared worse than a household headed by a white high school graduate. Why? Because these households' primary asset was their home, and because they were loaded down with debt to get that college degree, because they didn't have family wealth to make college affordable without going deeply into debt. So these are families that are less financially resilient. So when we thought about this project, we thought that the problems of an emerging population in a period of inequality had to be the central preoccupation of our efforts. And we don't have a lot of tools besides law and policy to work with. And so while I worry about their utility, I think that they have to be seen in a kind of hopeful way as a venue for opportunity and mobility. And I think that Patricia Williams, who said Black people never really believed in rights, that they believed in them so hard that they breathed life into them when it was none. That is our goal, is to help people find a hopeful way, to find each other, to build the networks, to make this known, and to remind America that Latinos and African Americans are not alone in this struggle, because white families increasingly are on the wrong side of the class divide. So this is our mission. It is ambitious. We're a scrappy little team, but we also welcome all of you who are interested or have ideas to share them with us, because this has to be a collective effort. And I can't imagine anything more important at this moment in our country's history. If we are to remain a democracy in the face of cultural privatization and deregulation and the diminishment of the public realm at a time when emerging populations need it the most.
Well, great. In a minute, I'm going to open it up, and I hope people have comments and questions. I just have these small responses myself. One, as Carlton so powerfully said, framing is key here. And here again, I would connect it to media. The ability of whether it's Fox News or MSNBC to come up with a tag phrase and then large, letters on your screen constantly telling you that's what's happening in America, or it's the webmasters that are doing it. And the very same phenomenon being described so very differently, producing the echo chambers, but nonetheless affecting the politics. So I think that's an amendment of the constitutional process that we used to have. Another point that does seem not in anyone's comment, but I just think it's in terms of taking a temperature of where we are right now. The Supreme Court has amassed power of a sort that is unprecedented. And so we can talk about the excessive power of the executive. I think it's so overshadowed by what the court is doing and limiting the power of Congress particularly. But so I just wonder, where is that in the picture, and what are the forms of resistance to Supreme Court grabs of power given the design of limits on constitutional amendments and so forth and so on. And finally, compromise. The word compromise came up several times. I think that the framers of our Constitution imagined that there would be compromise. Imagined by trying to design a system where there were no permanent factions, there would have to be compromise. We have made so many changes in the society where compromise is a bad word, it's impossible, it's difficult. What happens to ordinary politics when compromise is not possible? And it's not just then the Supreme Court, but courts as the resolvers of political disputes when it's black, white, yes, no, no compromise. Is that a contributor to the polarization that so many of you describe? Comments, questions? Come up to the mic. Vicki, come up and say who you are.
Well, first I want to thank the panel. This was just terrifically interesting, each of you. So thank you very much. I had in mind to raise the question of compromise when I was listening to Josh. It's absolutely right in a certain sense that you could say the design of the original Constitution was one of Gridlock. But it might also be accurate and more productive for the polity to say the design of the Constitution was one that assumed that the representatives and senators from these different places would practice the arts of compromise. And one of the things that has happened, and it's not just in the legislatures in the United States, but it is in the culture, is the phenomenon Martha talked about. In French, compromis is a bad word. In the UK, it's a good thing to be able to compromise. And we've moved. And so I want to encourage us to have a conversation about what are the constitutional virtues that are needed to make government work. And one of them is to understand that even if it's a bad thing for judges who in the common law world, we want our judges to be principled and consistent. That is not about compromise. But we don't want, I want to say, our representatives to be bound by virtues of judging. The virtues of being an elected representative are quite different, and they include the ability to compromise. And I started writing, actually, my first paper on this is and so I just want to say another way of thinking about the structure is that it was a structure that assumed compromise, that it assumed representatives who had one view would recognize that their fellow legislators were equally democratically legitimate and were bound together in a mission of common representation for the common good. So I'll stop, but that was the general
So thank you. So I appreciate the comment very much. It's well said. I think very often contempt for Congress is a proxy for contempt for the American people. And let me give you an example. I think Charlton mentioned that John Boehner never brought up for a vote the immigration bill. 4 days before that, a man by the name of Eric Cantor was primaried. He was defeated. And if you read various political articles, they say the reason why Boehner did not bring up for a vote was because of the Eric Cantor election. The GOP caucus freaked out. So when we say that the members of Congress won't compromise, I think it's say because they compromise, they'll be thrown out of office. So in reality, is this really a reflection of Congress or the American people themselves, which relates back to my first point of partyism? People are comfortable with their kids marrying someone of the opposite race, but not marrying someone who's the opposite political party. So before we reform Congress, perhaps we need to reform the American people, if that's even possible. Perhaps the research that Rachel and others are doing can help shape this demography. But I don't see this. And until the people, the very factions which Madison wrote of 200 years ago, I have tickets for Hamilton on Sunday, I'm thrilled. Until the factions are able to agree to each other, we do have a legislative gridlock. We do have choke points. Sandy Levinson hasn't when we don't have a parliament. And we end up with the executive amassing more and more power. So until perhaps a president can unite people, I don't know who that is. None of the candidates say seem like they're doing that. But until that candidate exists, I don't see this trend changing. Maybe Charlton has more thoughts on this, but I see the trajectory continuing as we are.
That was Vicki Jackson, just to name who it was. Thank you for that, and I think that this section could explore a merger with the family law section, and we could explore, inter-party marriages.
I like it. Real marriage equality,
So I'm Mario Barnes from the University of California, Irvine, and say I'm so pleased to have been able to witness a panel that includes 3 of my current or former colleagues, my current dean, my torts professor, and a guy who gave me the spectacular 5th floor office at the ABL. So thank you very much. So I guess strangely, or my question is directed toward you and your comments on the failure of securing constitutional protection for minimum entitlements. And I guess one of my questions is, throughout constitutional history, we have seen revisits and flip-flops in major areas of constitutional theory, the Commerce Clause lead among them. But even with regard to very important civil rights and civil liberties questions, the court has at least revisited periodically the position to either fortify its previous position or get some movement on the question. But it seems in the area of class and minimum entitlements, separate from San Antonio versus Rodriguez, and then if you count cases like Maher versus Roe, which aren't directly on point, but at least reinforce the notion that the government's required to provide a minimum benefit in most circumstances. Why haven't we had the question reoccur more frequently? Is that about the court, or is that about the broader set of political sorts of activities you've been discussing?
Yes. I believe that the Warren Court was moving in the direction of a constitutional protection of minimum entitlements. I think cases like Harper that spoke of poverty being a suspect classification were a first step towards it. Frank Michelman in the 1969 Harvard Forward argued for minimum entitlements based on the Warren Court's jurisprudence. We forget that even as recently as 1976, after National League of Cities versus Usury, which is a strange basis for it, but Larry Tribe and Frank Michelman wrote separate articles arguing the basis for finding a constitutional right to minimum entitlement. We also tend to forget that it was Richard Nixon, a Republican president, who proposed a negative income tax, which is a form of a guaranteed annual income. And of course, all of this has then disappeared. In terms of the courts, I think it disappeared most of all because the case that you identified, San Antonio Board of Education versus Rodriguez, that said that poverty is not a suspect classification. And there has not been a majority on the Supreme Court willing to reconsider Rodriguez. And I think it disappeared politically, beginning with the Reagan administration, that said that it was going to eliminate social programs except for a safety net that really wasn't a safety net at all. And since that time, there hasn't been a political will towards expanding social programs. So without the courts or the political will, I don't think it's been there. But I think the increasing wealth gap that Rachel and Bob speak about makes it ever more important that we as constitutional theorists think about how to get this back onto the table.
But can I sort of, one of the things that I thought we might have a conversation about this was in the independent living centers case, the Medicaid right of action cases, right? Because there was the sense of who are more vulnerable than Medicaid recipients, and recognizing a right of action in those instances, I thought might have allowed us to engage the extent to which they are marginalized in state political processes, right? And you see that in part by the fact that still there are states that have not expanded Medicaid. But the Democratic administration, right, made the argument that, look, this is a deal between the states. This is not a deal between anybody else. These people who are sort of secondary beneficiaries of Medicaid are just that, right? And that I think is that's a really big loss. That's a really big failure for the Obama administration to have articulated on the record multiple times in briefs to the Supreme Court that seem to suggest we don't care about the ways in which the political process fails poor people.
I'm Arnold Bowie from Texas Tech. Rachel, my question's directed towards you. Assuming your demographic projections are accurate, won't the problems of which you speak be taken care of by the electoral process? I assume that Latinos who are elected won't always mirror Ted Cruz and Margot Rubio. And that essentially, if you are close to a majority, or at least a plurality, you're likely to be electing legislators, congressmen, and maybe even presidents who share the perspectives you're talking about. And won't that fix the problem?
Well, it's an interesting question because I think some people feel there will be an natural solution because numbers necessarily translate into power. But one of the problems that we've seen is that the inequality, the wealth gap, the income gap, the education gap may seriously impede Latinos from fully exercising the power, the influence that they might otherwise have. So I will give you an example. My own home state of California. Look at those numbers, right? And we do have a strong Latino caucus, but we also have one of the worst K-12 systems in America. We have a higher education system that is under tremendous strain. And at the moment, most Latino kids are going to community colleges where the per capita investment per student is lower than in K-12, where they are warehoused for a few years, don't finish and don't transfer and get a 4-year degree.
And leave with debt.
And we also see a bifurcated employment market where most Latinos are working in dead-end jobs with no future. I'm an anomaly in California.
Is that likely to continue? I don't know what you're seeing at UCLA, but certainly at Texas Tech, while regrettably the African American students have seemed to be declining in recent years, the Latinos have certainly been increasing with at least a very significant minority of the population.
We have a larger percentage of Latino students at UC system than we do African Americans. African Americans are 6.5% of the California population compared to Latinos who are around 38%, but we have nowhere near 38% Latino students. And at the law school, we would sometimes have 11 or 12% because in Texas, you did a 10% plan. In California, we're under similar restrictions regarding affirmative action, but we did a 4% plan. And frankly, one thing is California doesn't have the same degree of segregation in many of its neighborhoods as Texas, which still has a legacy of Southern segregation, which was blacks and hombres aquí, right? So I think there are differences. The other thing is University of Texas has been able to keep its tuition lower, probably because oil is doing so well. Hope that things come back for you all over there. But I don't think we can be complacent and think that these issues will naturally resolve themselves because demography is destiny. I mean, I think we have to assume that if you have a growing population rooted in inequality, and frankly, in schools isolated by poverty and segregation, we need to worry about intergenerational mobility and opportunity. So I think your point is well taken, and when we do our roundtables, that will certainly be one of the questions we look at, but I don't think we can assume the consequence.
Well, just very briefly, I think, and this also goes to Martha's earlier question about resistance, we already are seeing resistance. I mean, Everwell, as a case, is a form of resistance. We see anti-immigration rhetoric in political campaigns and in various localities as forms of resistance. And certainly, there will be efforts to make sure that the Latino population does not get the vote.
Yes.
And so that is happening right now.
I should add some of those state cases that lower court cases that I've heard that involved ID requirements and things of that nature to deter Latinos from voting. And the Evanwell case was brought about by Edward Bloom, who's also involved with the Fisher case. And so originally Evanwell was portrayed as a rural-urban case in the media, to my shock and dismay. Finally, we're getting to hear about the implications for Latinos. But depending on how Evanwell comes out, Texas goes from being purple to being red again. And so I don't think that's common.
Good afternoon. My name is Shakir Sanders. I teach at the University of Idaho. I want to thank the panel, although I'm sorry I missed the first 4 panelists. Heel on my foot. The only shoes I bought. That's not the guys to answer. So my question is primarily for Rachel and Robert, and it's a little bit of a two-part, for which I will apologize. So you on the slide, you sort of showed us sort of the demographics for the Latino population, and then sort of the locations of the roundtables seem to correspond with those populations. And I wondered if you had given any thought to maybe getting off the beaten path a little bit and sort of doing some of those roundtables outside of our major areas. And that's not just because I want you to come to Boise, but because I want you to come to Boise. So, also, I do wonder what effects with this voter rights or voting demographic case, how do you think sort of the prison population issue for minorities could be further affected by the idea that we're going to sort of only look at the voting population for African Americans? That would be huge, and I think for Latinos as well. Thank you.
Sure. Well, the roundtables, I mean, it would be wonderful to go to Boise or other
Maybe not wonderful.
because there are large Latino populations outside the major areas. These aren't meant to be regional roundtables, and so we are going to try and reach in. As it is, it's pretty ambitious, and so probably the limits of resources may dictate that we can't actually do that. In terms of the question about sort of the effect of incarceration or mass incarceration on Latinos compared to African Americans, one of the things that we've strongly with is whether we should look at criminalization for Latinos. It certainly is a very important factor for African Americans. It is also important for Latinos. So-called education to prison pipeline, which has been documented about the Latino population as well. It's not one of the current priorities to look at, but it's certainly one of the things we're thinking about.
Hi, it's Suzanne Goldberg from, I am Suzanne Goldberg. I'm Suzanne Goldberg from Columbia Law School. Thank you all for the panel. As I was listening, I was thinking about where the ideas come from, right? And sort of which ideas, how have ideas historically gained traction in a way that has made a difference in constitutional law? And even thinking about some of the sort of early ideas around basic rights. So what law professor articulated, legal activists articulated, surfacing through the courts, through legislative actors and so forth. And then I was thinking about today and sort of what gets the traction. And on the one hand, I think that there's an argument that advocacy has become increasingly professionalized, right? So that the framing of issues is in the domain of paid writers who frame whatever goes on in Fox or whatever goes on MSNBC, as Martha was saying. And on the other hand, it's more democratized than ever before because anybody can write about anything, and people are gathering increasingly in the streets, at least relative to the past couple of decades. So I would appreciate just hearing your thoughts on how these different dimensions of surfacing ideas are playing into now how we think about movement in constitutional law, how we think about recognition, and how we think about resistance.
Charlton?
So the end of your statement made me think about, I think it's Scott Pohl sort of writes something about the collapse of the cap and trade legislation. And there was a sense that, right, the environmental groups had already negotiated with the corporate entities, right? And they were just ready for Obama's inauguration. I think they would have been ready for John McCain's inauguration, right? I think they thought, well, this is going to work under any administration. And what she seems to suggest is what they didn't take into account was the anger at corporate America that was going to take place between the nominating conventions and this inauguration, right? And so you come in with your corporatist environmental policy for which you've done no grassroots organizing, and you've made deals not with the quote unquote bad guys, but with the guys who are bad at the moment, right? And so you played into the hands of an electorate that didn't see the thing that you thought was some great big achievement as anything but yet another opportunity to get in bed with the same people we've been in bed with and the same interests we've been protecting for the last, clearly and explicitly the last 2 years, but as it seems, these last many years, right? And so I think that there is, again, to go back to your earlier point, the sort of elite framing, elite genesis of proposals raises a problem, right? That is to say, you've got to be attuned to where people are, right? Could there have been, can there be a politics around climate change, right? Because at the end of the day, whatever takes place, or whatever Obama's done in the EPA, that depends on who gets elected to the presidency in some sense. And so how do you create those sorts of lasting achievements? I think there's a recognition that this is a stopgap measure while you guys go out and a second turn at creating what looks like a grassroots politics. That's a much harder, more expensive set of endeavors, it seems to me, but clearly necessary.
It's interesting that we've been talking now for about an hour and 45 minutes about resistance recognition, and no one's mentioned the Occupy movement. Had we been together just a few years ago, if this is the title of the topic, Occupy would have gotten so much attention. It was not an elite movement, but it was not a movement, and it was a movement that got enormous media attention and coverage. And yet it was a movement that very quickly petered out and wasn't successful. I think what I want to say is we have much to learn from the movements that weren't successful as the ones that were successful in trying to figure out how to use constitutional change successfully in the future.
I have one thing. I'm actually reading in Galleys a book called Brown is the New White by Steve Phillips, which is looking at voter mobilization. And what he has concluded is that you would actually have, if you combine progressive whites with people of color who vote in a progressive way, a majority. It would be a bare majority, but it would be a majority. But we have failed to realize that power because of the reliance on things like broadcast ads, the failure to target Latino communities on the assumption that they don't vote, and a continuing emphasis on white swing voters. And I think that when you think about how that feeds into the media, which tends to also emphasize those same dynamics, you can see that we're missing some very important possibilities for mobilization. The other thing that I wanted to say is Bob and I were very conscious of the problem of a lack of attention in the main media, but also we have a project manager, Pilares Contreras, who's always reminding us everybody who's looking at social media. So we really wanted to have a strong social media presence because we're also finding that a lot of the younger Latinos are actually using their own social media platforms to communicate, organize, and think about the
But I just wanted to go ahead and give thanks to the moderator and our panelists again.
Thank you, Carol.
Thank you.
Everything is great. All good.